Good afternoon, everyone. I'm Carrie Abrams, Dean of Duke Law School, and it's my honor to welcome you all here today for our first session of Lawyers and Leaders, a new series that the Dean's Office is producing. One of the most rewarding aspects of being the Dean of Duke Law School is that I get to meet all sorts of fascinating people, many of whom are Duke Law alumni. Over the past 3 years, as I've traveled the country and more recently met with alumni by Zoom, I've often been struck by the inventive, inspirational, and unusual ways in which people make use of their law degrees. Lawyers and Leaders will provide me an opportunity to share with you, our community, some of the amazing people I've gotten to meet. I'll ask them questions about their law school experiences, their life experiences, and how they handle the ups and downs of navigating an uncertain world. I'm very excited today to introduce our first guest, Mark Elias. Mark graduated from Duke Law School in 1993, when he also received a master's degree in political science here at Duke. Mark is a partner at Perkins Coie, where he chairs the political law group. He is a nationally recognized authority and expert in campaign finance, voting rights, and redistricting litigation. He's also considered one of the leading recount and post-election attorneys in the country. Mark has represented dozens of US senators, governors, representatives, and their campaigns, as well as the Democratic National Committee, the Democratic Senatorial Campaign Committee, the Democratic Congressional Campaign Committee, the National Democratic Redistricting Committee, Priorities USA, the Senate Majority PAC, and the House Majority PAC. He also served as general counsel to Hillary Clinton's presidential campaign in 2016 and John Kerry's presidential campaign in 2004. As a litigator, Mark has handled scores of cases involving politics, voting rights, and redistricting, and he's successfully argued dozens of cases, including arguing and winning 4 cases before the United States Supreme Court. So welcome to Mark Elias.
Thank you for having me. Sorry about the audio there for a second.
Great to see you again.
Great to see you.
We'll have a conversation for a while, and then later on in the hour, I will invite our audience to send me questions during the Q&A function, and then I'll turn to some of the questions. So I thought we could start at the beginning. It's a very good place to start. I recall hearing a Do Re Mi song way back. You grew up in New York State, and I wondered if you're one of those kids who always knew that they wanted to be a lawyer.
Yeah, the answer is no. Actually, I grew up I went to high school in Rockland County, which is just north of New York City, and then went to college in central New York at a small college, Hamilton College. And honestly, I really thought I would go into academics. I had a very, very strong interest in political science, and really thought I would go get a PhD in political science. And my brother, who was older than I am and was at Georgetown Law School, said, you know, you ought to take the LSATs and consider going to law school. And I said, well, why would I want to go to law school? Like, I want to teach. He said, you can do anything with a law degree. Now, what I've learned over time is that mostly what you can do with a law degree is practice law. But I followed his advice. I took the LSATs, and then I applied to graduate programs and law programs. And then I got into Duke Law School, and I found out they had a joint degree program. And I'm like, oh, well, this is perfect. So, you know, I tell this to people because now, you know, I'm sure if that happened to someone, they would send an email to someone. I just picked up the phone because, you know, there was an email. I just picked up the phone. I called the dean and said, you admitted me to your law school. I'm interested in I've been applying to political science. Is there any chance I can do this joint degree? And they said, we'll call you back. They called me back like the next day, and they said yes. And then that was that. I kind of marvel in retrospect at kind of like how informal in a way things operated then. I don't recall there being a committee or anything about it. It's just like, yeah, that works.
Did you think you were going to do a PhD in political science at that point and still be an academic, or?
I did, actually. I thought, even though the JDMA program was a terminal MA, I figured I would do that and then apply to graduate programs. But that kind of didn't, obviously that didn't go that way.
So what happened? Why did you change your mind?
It's interesting. Part of it was that I met my now wife, who was also doing a JDMA program at Duke. And so she and I both kind of had interest in Washington, D.C. She had been a paralegal in Washington, D.C., and she had interest in going back. I was interested in politics generally. So that was part of it. Part of it was also I wound up sort of falling into this political law thing, and it kind of scratched a little bit of the itch I think that I had. But I have, I've had opportunity to teach here and there, and at some point it may be something I do.
So what are your fondest or least fond memories of law school?
So my main bitterness about law school was that when I started, the law school was quite modest in physical plant. It was the least renovated building. I don't know another way to put it. It was the dump of Duke University. Like it was like literally, it looked like a brick gymnasium.
I've
But
heard
what
it
it had
looked
going,
like a middle school is what people.
it looked like a middle school. That's exactly right. It looked like a middle school. But what it had going for it, though, was that the Sanford School didn't exist. So it had parking right across the street. And then they broke ground on the Sanford School, and our parking situation went away. And the business school wouldn't let the law students park in their parking lot. And they had a gorgeous facility. So we were like parking like, in no man's land, and still had this crappy building. So that's mostly what, but the high points were that it was I came from a very small liberal arts college. At that point, Hamilton was 1,600 students. I think it's a little bigger now. And what Duke Law School had was two things. Number one, it was small, both in its student population, but also the feel of the place. Like it didn't feel like a big impersonal environment, and that was important to me. And the second was that which may be less. I don't know what it's like obviously now, but doing the joint degree meant that I got over to West Campus. Like I would study in the stacks of the library there. I would have an opportunity to still feel connected to kind of really what is a world-class, preeminent university. And, even if it just meant, like I said, walking to the library there and sometimes studying there rather than in the law library, or obviously taking graduate school classes, I thought that was pretty unique, among law school experiences.
Yeah, but before COVID, when there were more of us walking around campus, I used to frequently run into law students all over the place. And sometimes I would follow the same study group around all day. It seemed like they'd relocated, and I would walk by them again. And it's nice to take advantage of the whole campus.
Yeah, I mean, I even remember going to the medical school library to study. Like it was just like really interesting places to kind of to visit and take advantage of, like I said, that kind of world-class, facility.
Is there anything that you wish, looking back, that you'd done differently in law school?
Yeah, I think that I probably was. I think I had two conceptions of law school that, one of which I think served me well and one of which didn't. The one that served me well is I very much knew I wanted to take the core classes, regardless of whether they were required or not. So, I never took a clerkship, but I took Fed courts. Like I took commercial paper. Like I very much felt it important to have a well grounding. I think where I didn't, what I didn't appreciate at that point, which I would appreciate now, is the value of clinics. Now, clinics were less prominent then than they are now. So in some sense, it's also a reflection of the time. But I think that sometimes students get very bogged down with the hard academic portions of it and don't realize that actually the clinics are like a really, really important part of learning.
Yeah, I'm really glad that about 70% of our students take clinics now.
Yeah.
I sort of think of it as it's a really steep learning curve the first time you represent a client, and better to do it here than
Yeah.
after.
Yeah. Yeah.
So what happened after? How did you figure out that election law, political law, was what you wanted to go into? And I guess another question is, did it really exist? It feels to me from reading about you and talking with you before that you kind of helped invent it in some ways.
Yeah. So I went to Washington, D.C. thinking that I would practice law at a big firm for a few years. I'd go either then back to graduate school or become a federal prosecutor and then probably go back to graduate school. Because it struck me that, having the opportunity to be in the U.S. Attorney's Office would give me trial experience that would kind of scratch the itch that then and sort of allow me to reset a career. So I got to Washington D.C. I graduated in '93, so I got there at the end of 1993. And in 1994, Republicans retook the House for the first time in 40 years. People now don't realize what a seismic shift that was. I mean, Democrats controlled the U.S. House of Representatives for 40 consecutive years. And it was an unexpected event that they lost control of the House in 1994. And part of the reason they did was that Newt Gingrich, who was the then agitator of the Republican Party, he actually wasn't the Republican leader, understood that you could use political attacks, you could use legal attacks, I should say, to affect the politics of elections. So up until then, races had been run mostly on, do you believe in this policy or that policy? He understood that if you went after your opponent on their ethics, on their compliance with the law or ethical principles, you could achieve mass electoral victories. And they flipped the House. And so the Democrats, who were shell-shocked by this, were looking to kind of build that sort of capacity back. And I was young, cheap, aggressive, and interested in criminal law. So that was sort of how I got connected to it. And then the 90s were a decade of just one criminal investigation of politics after another. I mean, you had the various independent counsels that ranged from, Whitewater with President Clinton, ended with Lewinsky and President Clinton. But in between you had, investigations of just about every iteration, every cabinet secretary, every major investigation of the Democratic Party. And so I wound up doing more and more investigate criminal and quasi-criminal work around politics. And from there, the field of political law just kind of like grew from really not existing into kind of now a still a relatively small area of law, but a much larger one.
So what role did you as a law firm lawyer play in those investigations? Like, what was the actual work you were doing?
Yeah, so the first stuff I was doing was basically taking opposition research against Republican members of Congress and turning them into complaints to the IRS, complaints to the Federal Election Commission, complaints to the House Ethics Committee. But it was basically taking, so I drafted the complaint that actually ultimately took down Newt Gingrich over his teaching of a class teaching of a political science class that violated the tax rules. So that was the first thing. Then after that, there just was the area of political law really didn't exist as a field. And white collar criminal law was just really beginning as a standalone specialty. So as odd and bizarre as it sounds like today, even as a mid-level associate in the 90s, there was just such a demand for lawyers who knew something about politics and something about the criminal law. I was doing everything from, representing clients who were being interviewed by the FBI before grand jury investigations, responding to endless series of document subpoenas, which back then were paper documents. You were producing, they were not electronic records. So a lot of it was done by hand. A lot of it was drudge work, but it was also like a tremendous learning experience. And I learned a lot about politics along the way, because when you review a lot of documents about how fundraisers happened, you learn a lot about how fundraising happens.
So I'm curious about, as you're kind of developing this new area of law, who are you doing it with? Like, did you have a mentor or a group of people that you were working with?
Yeah, so I definitely did, and I think that one of the things I tell law students, or for that matter, associates, who I talk to, is it's important to develop both mentors and sponsors, and they're two different things. My mentor was Bob Bauer, who subsequently went on to become White House counsel under Obama, now teaches law at NYU. Perhaps you could lure him away, but he was the only he and a lawyer at a law firm Weiler and Fielding named Jan Marin. Actually, Jan's not there anymore; just recently retired from there. Probably literally invented the area of law. But I was Bob's associate, and that was essentially, that was that. But it's really important for law students to figure out who is going to help them guide their career in making decisions. Do I want to do more of this or more of that? I mean, there came a point where I had to make a decision. Do I still want to do commercial litigation or white collar work that is not political in nature? Like, do I want to turn that work down and only focus on election and politics? So having mentors are important because they can help you guide through those decisions. But I think that for a lot of law students and young lawyers, they don't realize that having sponsors are even more important than having mentors. The person who will put their credibility on the line to promote you with a client or within a firm or within an industry is super important. And those people are harder to find than the first.
Mm-hmm. Yeah, I often feel like I would not have gotten any of the places I've gotten without the sponsors, and I can just, list who they are. And I've been trying to have Zoom calls with them over the last few months to thank them, because it's been a little bit quieter and I've been able to do that, but that makes such a huge difference in someone's career. Can you say a little bit about luck? I hear a lot of people say they were lucky and they happened to be in the right place at the right time and things worked out for them. But there's also like something to the idea, I think, that you make your own luck, that you're able to capitalize on opportunities when you see them. How much of that did you have to do to kind of move into this area that was developing?
So I think it was both. I think that there was definitely luck in that I happened to be graduating from law school at a particular moment in time when a field of law was going to sort of propel forward. And had I come out of law school in 1989 instead of 1993, that trajectory would have looked different. So there is definitely an element of luck to it, and there's really not a huge amount you can do about that. I do think that rather than saying that you make your luck, I think that people need to be intentional about their careers. I mean, one of the things I say to folks is, like, if you're doing a meeting, where, like, with an informational interview, or for that matter, interview for a job, like, go in knowing what you want to get out of it. I'm always surprised by the number of people who will ask to talk to me for advice, and by the time we are done, like, they won't have made any ask. Like, they won't have used their time to ask me to do something. Like, they have just kind of like walked through the paces of the meeting, but there isn't any intentionality to it. So, the intentionality doesn't have to be hire me, right? But you need to have a sense of, like, how are you going to get from where you are to where you want to be, and what are the important steps? They may be skills steps, like, I want to learn how to take a deposition. They may be relationship steps, like, I want to meet, so-and-so. I want to learn what it's like to deal with a client, which is one of the reasons why I do think clinics are important, because it is ultimately a client business. It's ultimately a customer service business. And like, if you don't have that skills, you're not going to succeed no matter how good a lawyer you are. But I do think having intentionality, I think of more than making luck. Like the luck was the luck. And that, there's no way I can have done anything that I did without it. But then after that, it was just being intentional about the decisions I was making.
Do you have other advice for our students who are about to become first-year associates or first-year lawyers of some kind? And especially right now where we're still in, but I hope we're coming out of a pandemic, but it's a time when there is a certain amount of luck in the world that's both good and bad potentially for people's careers.
Yeah, so I mean, I think I would break it into a few categories. I think if you're going to a big law firm, it's a difficult time to start at a big law firm because they are big and everything is remote. So it's hard to get your bearings and get known and understand the culture of the place when you are in person. And I can only imagine what that's like when you're not in person. So for folks doing that, I think my advice is like, do really good work, but don't over stress it. Like don't over worry whether you are, the circumstances are the circumstances. So like nobody is getting to know anyone. Like, so don't over worry it. Do good work, and presumably sometime in the near future we'll all be in person, and then those other things will fall into place. I think if you're not going to a big law firm, I think there's actually a fair amount of opportunity out there, because I do think that a lot of the we're going to hit a period of serious growth in the country and in the economy and in the legal economy, and we're going to pivot from a world of kind of everything being closed to everything being open. So I think for those folks, I actually think it's a pretty bright. I think it's actually a pretty good time to be coming out into the world of the lawyer.
That's really great advice. So I'm really dying to ask you about some of the high profile cases and matters that you worked on. And one thing I'm particularly interested in is hearing more about what does it mean to be the general counsel for a presidential campaign? You were John Kerry's GC and then Hillary Clinton's. What is that?
So it's an interesting role, because presidential campaigns are sprawling operations. I mean, they have gotten much more sprawling. I mean, the Kerry campaign in 2004 raised and spent $118 million over the course of a year. The Biden campaign, I don't know the exact number, but it's got to be almost $1.5 billion or more. I mean, so you're talking about a huge, dramatic increase in the amount of money in politics generally. But being the general counsel to a president, I mean, the Clinton campaign was about $1 billion. So I'm guessing the Biden campaign was at least $1.5 billion when you count the campaign itself and the ancillary organizations to the campaign. And so think of it this way: being the general counsel to a $1 billion enterprise that has operations in 50 states, it has thousands of employees. They are driving around at night after drinking way too often. They are losing laptops. They are being hacked by the Russian Federation. You're running television advertisements that are highly critical of people, so you get sued for defamation. You're in a heavily regulated industry, right? Because campaigns are regulated by the Federal Election Commission. So it is, and you're entering into, multi-million-dollar vendor agreements, right? You're renting office space. You're entering into agreements, license and trademark. Trademark has been a huge growth area of campaigns. In 2004, with the Kerry campaign, we had a logo, and if you wanted to print T-shirts, you just took our logo and you put them on a T-shirt. And then you sold the T-shirts. The Obama campaign with the Rising Sun logo, what that was a trademarkable item. And the Obama campaign understood that by creating a trademarkable logo, they could reap the revenue of all of the merchandise sales. So all of a sudden in 2008, rather than here's a logo, everyone, go print your own merchandise, the Obama campaign maintained a monopoly on the sale of merchandise and generated a huge amount of revenue, which is now the model that everyone has used. So everyone who hated the Hillary Clinton H with the arrow, the reason why you had an H with an arrow, same thing, is you're creating a mark that is able to then be used on merchandise. Biden, same thing. You saw whether you liked or didn't like the Biden logo. So campaigns have gotten to be very, very, and of course, MAGA on the other side, the Trump marks made them tens of millions, hundreds of millions of dollars of revenue. So you wind up being general counsel of the campaign is a lot of being, a lot more of being a regulatory and business lawyer than I ever cared to be, but that's what it is.
And what does that look like? So you're in DC with a team, and is that where you are most of the time, or?
Yeah. So before the pandemic, yes, I worked in DC. With the Kerry campaign, it was easy. They were headquartered in DC. My firm was actually the general counsel of the Obama campaign. I was not personally, but Bob Bauer, my partner, who I mentioned, he was. So I worked with them some. They were in Chicago, which was harder because it was a lot of travel for him. With Hillary's campaign, it was in Brooklyn, and it wasn't a bad. That's a relatively easy either flight or train. So I would go up there, every week for part of the week. And then, inside the campaign, and Dana Remus, who's now White House counsel, was the general counsel of the Biden campaign. The Biden campaign was the first campaign to have an in-house general counsel. So Dana, who's a wonderful lawyer, by the way, fabulous lawyer, great person too. Dana was the general counsel to the Obama Foundation, and then moved and became the in-house general counsel to the Biden campaign. And then they used a series of outside law firms for sort of pieces. So like I did post-election recount work for them. So
how well do you get to know the candidate when you're representing your campaign?
So usually, for me, let's put it this way: in my practice, I usually know the candidate really well because I usually have represented the candidate before. So, for example, I was a general counsel to Kamala Harris's presidential campaign. Like I know the vice president. I knew the vice president. I was representing the vice president before she ran for Senate. So like usually it's an ongoing relationship. John Kerry, I had known before when he was a senator. You can see a theme here, which is that I tend to represent people who were in the Senate who then run for president because I do so much work representing senators generally. In fact, I and my firm, we represented 8 presidential candidates in 2020. We represented Kamala, Amy, Klobuchar, Elizabeth Warren, Cory Booker. You can see the theme here, right? So we oftentimes will represent people. In fact, in the year that we represented I represented John Kerry. We also represented Dick Gephardt, who was a House member, ran for president, and Joe Lieberman, who was a senator at the time. So our model is that we tend to know them because we represent Democratic House members, senators, governors. So then when they run for president, it's unusual for us to take on a client. We usually won't take them on if we haven't had an existing relationship with them before.
Do you ever get into conflicts? Like you mentioned that,
oh yes,
libel is one of the issues with your ads. And if people are running against each other, I would imagine there could be a conflict there.
Yeah, look, conflicts are, for students, there are 2 things about being a lawyer that are the least pleasant, I think. One are timesheets, and the other are conflicts. Keeping time is terrible, but it's something you have to do. It's a pain in the neck to do. And the other are conflicts, and you run into conflicts both between the circumstance you're talking about, but also honestly, you run into conflicts because, if you're a big firm, you may be contracting with Oracle, and your firm may represent Oracle, right? So there are all kinds of conflicts that come up. Business conflicts come up more often than anything else. We have a few rules that help us avoid conflicts as best we can. One is we don't attack other Democrats. So we make this clear to our clients coming in. And that's not just even like where we represent the other Democrat. Like, as a practice, we are not a good fit for you if you want to use your lawyers to be adverse to other Democrats. That's not our brand. We are very good at being adverse to Republicans. So you want someone to say, Donald Trump is an authoritarian danger to democracy, the 25th Amendment should be invoked because he's incompetent. I'm your guy. But you're almost never going to hear us in a posture or advising in a posture adverse to other Democrats. So, but we deal with it with conflict waivers. We will sometimes set up walls between clients. We did with the presidential campaigns, where we have different teams of lawyers working on different things. But at the end of the day, we still won't be adverse in a legal sense to their interests.
So what about when a candidate who you're representing or you're representing their campaign does something particularly egregious? Like, I'm wondering if there's a line for you where you won't represent that person anymore, or kind of what that's like to represent someone who's done something controversial. I'm thinking about the email server with Hillary Clinton, or maybe on the further down the spectrum, maybe Al Franken, the accusations of sexual impropriety. Like, how do you think through that?
Yeah, so look, I think that we all have lines that we have to draw. I have never had to. I should never say never, because there may be a circumstance out there that I'm not thinking of. I can't think of the circumstance in which I have felt the need to end a client relationship over it, where the client didn't also want to end the relationship. Do you know what I mean? Like it is. There are times where it is clear to them that the advice you are giving them is where they don't wish to follow your advice, and you don't believe that you are the right fit to advance their interests in the direction they wish to go. So, like, I can't think of the circumstance where I have been like, I need to jump off this ship. It happens very infrequently, by the way, but there have been a handful of times where it's like, my advice is you do X, you don't want to follow my advice. You actually you either don't want a lawyer, or you don't seem to want me as your lawyer. and usually they're like, yes, you're right, I don't want you as my lawyer. And then it's like, okay, let's make a transition. In the case of, I never faced that circumstance with Secretary Clinton. I thought Secretary Clinton, or the Clinton campaign. I think that, first of all, just to be clear, so that there's no misunderstanding, Hillary Clinton also had a personal lawyer for many years, David Kendall. So I wasn't handling the email server, but I also don't want to distance myself from it, because I would have. But my role was representing her as a candidate, not representing her as Secretary of State. But I never faced that with Hillary's campaign. Nor, frankly, with Franken. I was his recount lawyer in 2008 when he won a very close recount. I was very proud of that work. When he, at the end of his time in the Senate, when he made a decision to resign, he made that decision. But it was not because I shouldn't say anyone, I don't know anyone. It wasn't because I was not willing to represent him. I'm not sure, by the way, like whether I would have been willing to represent him would have been the trigger point of his decision making. But I was not. If he had gone before the Senate Ethics Committee, I would have represented him before the Senate Ethics Committee.
Let's talk about the 2020 election. We could all guess from a mile away or 100 miles away that there were going to be lawsuits following the presidential election. So Can you say more about what your role was in the election and post-election, and when did you get involved and what kind of preparation were you doing?
Yeah, so I think breaking it at pre-election, post-election is the right way to think about it. Pre-election, I have been litigating voting cases and voting rights cases for a while, and after the 2016 election, and I was sort of tossing about like, what do I do now? In early 2017, I decided that I was going to take on a greater role of in the fight for voting rights, particularly around voting rights for Black, brown, and young voters who were being sort of systemically disenfranchised. And by systemically, I mean that both in overt ways, but also in non-overt ways that were obvious and intentional, and ways that were not obvious and not intentional. And I was particularly focused, frankly, on the second, the not obvious and not intentional, because I thought that they were having a pernicious effect in the outcome of elections. And so
what are some not obvious and not intentional examples?
Yeah, so I'll give you two. The first is ballot name order. It turns out being listed first on the ballot gives a candidate a measurable advantage. So that can have both a partisan effect if you have, if for states where they list the names based on the party of the governor, like Florida, that can have a partisan effect of perpetuating the incumbent party. But it can also have a racial effect, because it turns out, for example, Asian names tend to be lower in the alphabet than anglicized names. So you can see actually an effect in some legislatures in the composition, the racial composition of legislatures. So that's a really good example of something that I don't think anyone passed a name order statute in order to discriminate either on a partisan basis or on a racial basis, but as a fact. The second one, which is probably what I became as well known for in 2020 as anything, were attacking absentee ballot rejection laws. What we know from 2018 data, which is the data we were using when we were bringing these lawsuits in 2020, is that, for example, in Florida, if you were 18 to 21, the rate of rejection for your mail-in ballot was 5.4%. If you were over 65, it was 0.6%. So 1 in every 20 voters, 18 to 21, had their mail-in ballots thrown out, and 1 in 200 older voters. If you were Black or Latinx, your rate of rejection was over 2%. If you were white, it was under 1%. So there was more than a 2-to-1 differential based on race in whether or not the ballot you cast was going to be a ballot counted. And so this differential between cast ballots and counted ballots became a focal point of something that I later wrote about as called the 4 pillars, which then became sort of a shorthand for a kind of litigation that was very pervasive in 2020 to try to decrease the rate of rejection of mail balloting overall, but also try to flatten out the differential based on race and age and also gender. Actually, women had a higher rate of rejection of mail ballots in the Stacey Abrams race in Georgia than men did. Now think about that for a second, Carrie. Why would that be? And I'll tell you the answer, which I don't have data to support, but I'm positive I'm right. Maiden names. So basically, woman registers under maiden name, gets mail ballot, fills it out, signs the back of the envelope with married name, ballot gets rejected for mismatch between the two names. So there are these things that are kind of hidden in the system that have these impact on voters, and I became very focused. So I litigated about 100 and some odd, 115 cases pre-election, either filing a lawsuit or intervening the defendant. And then the post-election, I worked for the Biden campaign and the DNC. So post-election was simple. I was responsible for the litigation and recounts around counting and casting of ballots, which wound up being about 60 cases.
And so those cases, one thing that I think a lot of us observed that may have come as a surprise was it didn't really seem to matter the political party that the judge had come from. Judges were throwing out cases brought by the Trump campaign. And I think there had been a lot of anxiety in advance that maybe he had the judiciary locked up. So was that anxiety you shared? I mean, were you surprised by that?
So look, I had anxiety, before I had anxiety through the whole thing. I mean, in the pre-election world, I actually sued North Carolina and was one of the states that I had a lot of anxiety about. In fact, maybe the most anxiety. I had sued North Carolina over their treatment of absentee ballots. I had won a settlement with the state of North Carolina. And that settlement was then challenged through direct appeal through the North Carolina courts, through a collateral federal court case brought by the legislature, and through another collateral federal court case brought by the Republican Party of North Carolina. Now, as I once said to a federal judge in North Carolina, this is not how they taught me that this is supposed to work in Fed courts at Duke. I don't think the judge was a Duke fan, or at least he was not a fan of that comment. Because honestly, I didn't understand how the Republicans around the country got away with this idea of attacking state court judgments in federal court, since I thought what I learned in law school, and since is that if you want to attack that, you go through the state court system up to the Supreme Court. But that was very, very stressful, and we wound up prevailing there in the Fourth Circuit en banc, and then before a divided Supreme Court. But it was stressful. In the post-election, which is what you're referring to, which is where basically Trump didn't win. He won one case, very small case in Pennsylvania that didn't amount to much, but where judges of every stripe were tossing out their lawsuits. Look, they had frivolous lawsuits. I mean, these weren't close, difficult questions. I mean, they had a lot of crackpot lawyers arguing a lot of really stupid things. And so I got a lot of praise and credit for the post-election litigation, but honestly, a lot of it was traffic copping, teams to bat down, theories that, Hugo Chavez had somehow rigged the election, even though he's dead. So yeah, it was nerve-wracking. I do think, to your question, I do think that there were some judges, or some courts, I should say, where they purposely had Trump appointees or well-known conservative appellate judges write opinions precisely to put a very clear emphasis on the rejection of the claims. And that was good to see.
We're starting to get some questions coming in. So I want to tell the audience that if you have questions, go ahead and send them in the Q&A, and I will get to as many of them as I can. I think one of them that follows from what we were just talking about is a question about North Carolina. So what do you think lies ahead in North Carolina in election and voting rights litigation?
So I've sued North Carolina as much as I've sued anywhere. I was part of the lawsuit brought against the state of North Carolina after they passed their monstrosity of a bill in 2013, which is the one that was found to have targeted African Americans with surgical precision. You'll be happy to know that in that case, among our plaintiffs, we found an individual whose last name was Duke. So I quickly moved him to the front of the list. So the case caption would be Duke versus North Carolina.
Thanks a lot.
Yeah. So I represented what were known as the Duke plaintiffs, even though it had nothing to do with Duke University. And then I sued them over redistricting. I won in the Supreme Court. I've sued them over redistricting again. I sued them several times over voting rights. Look, I think that the challenge in North Carolina is that the Republican legislature believes that the only way it is going to maintain electoral control in the state is through anti-majoritarian means, which is actually kind of weird because I'm not sure that Republicans in North Carolina wouldn't maintain majoritarian rule, at least in some cases, if they let there be free and fair voting rules. But it has been persistently one of the most regressive legislatures when it comes to voting, redistricting, anything involving democracy. And the fact that they just censured their senator for voting to impeach Trump tells you kind of where they stand.
We have a question about Georgia too. So the question says, it seems that the legislature is preparing to push even more voting restrictions now that the state has turned blue. What does this mean for the 2022 Senate and gubernatorial elections?
Yeah, I'm worried about Georgia. Georgia looks like it may be on the precipice of doing what North Carolina did a few years ago. I represent both Warnock and Ossoff, the two senators who just won. We had 13 lawsuits over the runoff. Like, while everyone was focused on the litigation we're doing around the Biden campaign, we had between November 4th and January 5th, we had 13 lawsuits in Georgia. The Georgia Republicans are doing this for two reasons. First, because they think it'll help them electorally, which, you know, is sad, but that's what they think. The second is that they are just trying to show fealty to the base that is pissed off about the recount and the outcome of the election. And that second impulse is truly, truly dangerous to democracy. If we have legislatures passing laws that they know are wrong, they know are simply, you know, suppressive for the sake of being messaging laws to message to a group of constituents who don't believe that there should have been lawful ballots counted, then we're in a lot of trouble. And that's what I think that Georgia, that if the North Carolina bill was passed with surgical precision, very strategically to disenfranchise Black voters, I think the Georgia bill is being put together to surgically disenfranchise Black voters for the purpose of convincing a bunch of QAnon people that Donald Trump really won the election. And in a way, that second one is scarier than the first.
What about the discretion that county clerks and local election officials have over absentee ballots? Is that a problematic aspect of election administration? Do you think we need reforms around how absentee ballots are managed?
I do. I think we need reform around the way absentee ballots are handled. I wrote an article. If you go back and look on my website, Democracy Archive, you'll see I wrote an article in January of 2020, so over a year ago, saying that we have an epidemic of uncounted ballots in America. Okay, that's what I said in January. Coronavirus didn't yet exist on our consciousness. We have an epidemic. We have had an epidemic of people's ballots not counting. You know, New York 22, where we just had this very close House race. It turned out in the course of the counting of the ballots, they found out that in Oneida County, they were not processing mail-in applications or registration applications because the clerks got overwhelmed, so they put them in a drawer. Like, the fact is, the problems that 99% of the problems we have in election administration is not the counting of fraudulent ballots. There is vanishingly little fraud. The biggest problem we have in this country is that we tolerate a lot of people getting disenfranchised because the local election workers are overworked. I'll give you one more example that will illustrate this. So we all know there's very, very little voter fraud. Even the most ardent conservatives on this call would say it is not a lot of people. They would say it's more than I think it is, but it's not a lot of people, but we can't let it grow. So answer this to me. For everyone who talks about how wonderful the Colorado model is of all vote by mail, Colorado in 2016 rejected 12,000 absentee ballots for signature mismatch. Does anyone on this call really believe 12,000 people fraudulently voted? If you don't believe 12,000 people fraudulently voted and you think it's more like 12, even if you're a Republican conservative on this call and you think it's more like 1,200, what the hell happened to the other 10,000, 11,000 voters? Like, so we have a system in this country where it's just simply too easy for election officials not to count votes. And so I do think we need to reform, but that's a different kind of reform than what most people are talking about.
Sorry, I was trying to unmute there. We are getting a lot of questions about kind of how you decide where to work and whether your work environment and the organization you choose to work for is consistent with your values. So there's one about, how can law students avoid joining law firms whose work requires them to compromise their core moral and political beliefs? There's a question about, can you talk about differences between doing voting rights at a law firm versus at a nonprofit? And then a question about, could you represent a candidate or a party if you didn't share their political views? So maybe I'll kind of lump those all together.
Sure. No, those are all good questions. So look, I didn't care enough about being a lawyer to have represented, so when I first got to Perkins, they did not assign lawyers to particular areas. We were a small office. And early on in my career, like early on as in like the first month, I got assigned to a business transaction in New York between like some bank and some other company, like selling something between them. And like literally, I said to my then girlfriend, now wife, I'm like, honestly, I don't care enough about being a lawyer to do this. Like, I'll just go back to graduate school now, because this wasn't my life ambition. So I'm a bad person to ask, because like for me, no, I wouldn't do work if it wasn't for, I grew up a Democrat. I was a Democrat before I did this work. I believe in the values of the Democratic Party. It's not perfect by far. My own views within that party are not always the views of every candidate I represent, but by and large, not even by and large, I can comfortably say that the people I represented, I have been, aligned with my political values. I don't bring voting rights cases to make it harder for anyone to vote. All my voting rights cases are making it easier to vote. And so to me, that's important. I think for some of you, that's very important. And for some of you, that is less important. If it is very important to you, then this is what I mean about being intentional. Like, then be intentional about it, but don't hide your head in the sand. Like if you go to Jones Day, which is a very good law firm and has some excellent lawyers, don't get me wrong, like they have some great lawyers, but like you're gonna be on the other side of voting cases from us. You're not gonna be on this side. So like know that that's what the firm is doing. And you need to decide for yourself, is what matters what you do, matters what the people you work with do, or is what matters what the overall firm does? Because those are three different sets of questions to ask, and be honest with yourself about what compromises you're willing to make and not. The one thing that I'll say is I do fault the Republican, you asked about, have I ever, not aligned and gotten out of and wanted to get out of a case or get out of a representation. I would not have represented Donald Trump in the postal. I wouldn't have represented Donald Trump, period, because I thought he was an authoritarian, anti-democratic force for evil. But I definitely would not have represented him in the post-election. And I think that the lawyers who did that, who didn't back out, I think should have to answer for it. Because the fact is they were advancing positions to undermine democratic norms and institutions. And frankly, I think the bar should have a rule against doing that. I don't think lawyers should be allowed. I think if lawyers have an obligation to the court, they should have an obligation to the Constitution and to democracy, and undermining free and fair elections, suing 4 states to say that they should have their votes entirely thrown out. If you're a lawyer in Texas, should have consequences. So I think we each draw these lines in different places, but you need to be comfortable. And to the nonprofit versus for-profit, big law firms are always going to be, are never going to be as pure as a voting rights nonprofit. You're never, you're not going to be associated with a nonprofit with a firm that has other clients that may not share your values, and you're not going to be beholden to the client's ability to pay, the client's peculiar interest in an outcome. So it's a little different. I think I've been able to get to a place in my practice where around voting rights, we are able to be pretty full-throatedly just pro voting rights, and that's a nice thing.
So one thing I've read about recently is that you have been talking about wanting to help restore democratic norms post 2020 election. And one of the questions that's come in is about your decision to create your website Democracy Docket. And I'm wondering if that's related to that. But can you say a little bit more about what it means to be pro-democracy as opposed to just pro-democrat?
Yeah, so I created my site Democracy Docket because I thought it was important to accomplish three things. Number one, there was a lot of misinformation about cases. You know, this is something that actually I would love for a law school to tackle. But it is absolutely outrageous that the general public has to pay for access to cases on Pacer or Westlaw, right? The fact that that the public can't have direct access to what it is the courts are deciding in many places, I think is a real problem. Plus, these cases are oftentimes like Greek to the average person. So one of the reasons I created the website was, and why it's still going and expanding, is I want there to be a place that if you get into an argument or a discussion with your uncle who says Donald Trump never had a chance to argue X, you're not just left saying, oh, yes, he did. You can actually say, here's a website, and you can go and you can pull down the brief that Donald Trump filed. You can pull down the opinion the judge wrote yourself, and it's free. And we'll have a nice, clean little description of what happened that you can believe or not, but then you can just read the decision. So that was one reason. The second is that I think that there isn't a forum, or there hasn't been a forum, where people who want to just focus on issues involving democracy restoration and democracy expansion have to go. You know, you can write in the New York Times, or you write in the Washington Post, you know, or, you know, the various journals now, a number of, I don't know if Duke Law Journal does, but a number of the journals now have these sort of quasi-online forum things. Like, but I wanted there to be a place so that, you know, Michael Bennet came to me, Senator from Colorado, was like, I want to write something about voting rights. You know, Stacey Abrams has wanted to post something longer form about how Democrats won in Georgia. Nick Stephanopoulos, who you may know, is a law professor who specializes in redistricting. He wrote something. So I wanted there to be a forum that is just about these issues, and where people from different perspectives, Aloe Black, recording artist, wrote something, right? Where people can sort of offer their perspectives on voting and moving forward. And then the final thing is to try to provide accurate information to people about voting. You know, there's a lot of misinformation. I think that'll do. So I'm very focused for the next 2 years, 4 years, in trying to figure out how do we move forward from a period in which our democracy has come under rhetorical attack and literal attack in the U.S. Capitol. And I think there's a huge role for lawyers to play in that. But it's not just going to be sitting at a big law firm. You know, it's going to be speaking out. The quote, if there is one thing I cite more than anything else, it is the dissent. I'm sorry, not the dissent. It is the concurrence of Justice Scalia in Doe versus Reed. Doe versus Reed involved an anti-gay marriage ballot initiative from Washington State. And the question was whether or not the people who signed the anti-gay marriage ballot initiative could shield from the public the identity that their identity from having signed the petition. And the Supreme Court said no, that signing a petition is not, you know, it's not a private act, it's a public act. And Scalia, writing for himself, talked about the need for civic courage and for people to stand up. Now, he may have been on the other side of this issue, but he talked about the importance of standing up, you know, and speaking out in the public square. He talked about how originally we voted in person, right? Originally, in the colonies, all voting was in person. The secret ballot wasn't even a thing. And so I think that one of the roles that lawyers have to fill is they have to stand up and speak out, and they have to be heard. And that's going to mean saying uncomfortable things to people who find it uncomfortable. But if you're not willing to do that, then I think you're not meeting one of the core obligations you have as a citizen.
Well, thank you so much, Mark. You are an inspiration to us, and we're so proud that you are a Duke Law alum. I wish we could talk all day. And given the wonderful questions that have come in from our students and other attendees, we could talk all day because there are lots of great questions that we haven't gotten to. But thank you so much for being my guest today and taking this time out of what I know is a really, really busy schedule to be with us.
Thank you. And let me just say to all of the students listening, how fortunate you are to have Carrie Abrams as your dean. You know, I've had several deans from when I started law school till today, and it is sometimes not obvious to law students how important that person is to advocating for you and to setting the right tone for a law school and a direction of a law school. And you all are incredibly fortunate and in great hands. So thank you.
That is very kind of you to say, and I didn't even pay you. Thank you so much. Have a great day, everyone.
Bye-bye.